Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Jaanya Seth. She is going to speak on Uniform Civil Code. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Jaanya to commence with her lecture. Thank you.
Hello everyone, my name is Jaanya and the topic for today is Uniform Civil Code, also known as the UCC. Today, the topics that we are going to cover are the historical background, UCC in independent India, purview of the UCC, landmark judgments, followed by countries that follow and don't follow the same. The debate on UCC started with the framing of the constitution and has been kept alive by the judiciary as well as the political class. The issue has again been brought to the forefront of public debate with the recent judgment of the Shaira Bano case, which invalidated the triple talaq. This has also coincided with the Law Commission inviting public consultation on UCC in October 2016. But before we move on to the nuances of Uniform Civil Code in context of multicultural polity of India, we should begin by understanding the constitutional, judicial, and the political history of UCC debate. Article 44 of the Constitution provides for a uniform civil code for the citizen. It states that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. What does the Uniform Civil Code mean here? We already had a uniform criminal code, one that applied to the entire territory of India. We also have a number of civil laws that are uniform, like the Indian Contract Act, the Transfer of Property Act, the Civil Procedure Code, etc. So this Uniform Civil Code really referred to family laws, sometimes called personal laws. The Muslim members of the Constituent Assembly who spoke on the Uniform Civil Code were all men except Tajmul Hussain from Bihar. All of them fought relentlessly to exclude the Muslim community from the article. The other end of the spectrum were the three stalwarts for social change and equality, Meenu Masani, Raj Kumari, Amrit Kaur, and Hansa Mehta, whom each wanted it to be made a fundamental right. However, neither viewpoint was accepted. It was made a directive principle of state policy, postponing the problem to be sorted out by a future government. But it has been more than half a century since the Article 44 was enacted. But successive governments have not shown the necessary gumption and courage to act upon it. Though on and off, the need for a uniform civil code is debated. A small section of the Muslim community, the India's largest minority, opposes it on grounds of religious interference, and the larger but quieter voice of gender justice is dispelled, resulting in uncertainties and continued discrimination. Let us now start with the historical background. The story of the Uniform Civil Code in the Constituent Assembly begins at the committee stages of the making of the Indian Constitution. The subcommittee on fundamental rights was tasked with drawing up a list of fundamental rights that were to be incorporated in the Constitution of India. An initial step that the subcommittee took was to request its members to come out of their personal drafts of fundamental rights. In the submissions of Dr. B.R. Ambedkar and others, we find provisions that call for an adoption of the Uniform Civil Code. Around the same time, members of the subcommittee were toying with the idea of splitting the fundamental rights into two parts, justiciable and non-justiciable rights. As the terminology suggests, the former would be enforced by the courts, whereas the latter would not be. After a couple of sittings, the subcommittee submitted its report to the parent committee, the advisory committee, with a list of fundamental rights split into two parts. The Uniform Civil Code found itself in the second part, the non-justiciable. The tussle with respect to UCC between different socio-religious and political groups reached its zenith after the Supreme Court's judgment in the Shahabano case. However, after deciding several cases on similar lines and focusing upon the need for UCC, the Apex Court has refrained from directly engaging with the issue by referring it as a matter which falls within the purview of the legislature. The issue of the UCC attracted the limelight of public discourse, especially legal, in the country after the BJP's return to power with a strong mandate in the 2014 general elections. The idea of UCC owes its origin to the concept of a common national identity, which is what the BJP had preached. The idea of UCC owes its origin to the concept of a common national identity. While making a case in favor of UCC, K.M. Munshi in the Constituent Assembly observed there are many factors and important factors which still offer serious dangers to our national consolidation, and it is very necessary that the whole of our life so far, as it is restricted to secular spheres, must be unified in such a way that as early as possible we may be able to say that we are a consolidated and strong nation. Now we'll talk about the Uniform Civil Code after independent India. After independence, only one act was passed by the Indian Parliament that applied to family relations of all Indians irrespective of their religion. The act was the Special Marriage Act 1954. The act permitted the parties to marry each other without renouncing religion for the purpose of succession. The Indian Succession Act 1925 governed them. The Special Marriage Act 1954 was not in consonance with the marriage and succession laws of the Hindus and the Muslims, yet no objection was raised and no exceptions were demanded. However, when the Indian Adoption Bill was introduced in the Rajya Sabha in 1972, the debate on Uniform Civil Code came to life again. Presenting the bill, the law minister remarked that it was the first step towards Uniform Civil Code. Even though the bill permitted all Indians to adopt any child without reference to the religion of the child or adoptive parents, yet unfortunately this bill could not be passed as an act. The adoption bill was only an enabling legislation and compelled no one to adopt a child. As regards the adoption an Indian child by a foreigner concerned, Indian law is still silent. In Lakshmikant Pandey versus the Union of India, the Supreme Court laid comprehensive guidelines to regulate future adoption of any child belonging to any religious community in India. The court prescribed uniform norms and procedures to be followed by an adoption of an Indian child by the parent. So there are certain matters that come in the purview of the Uniform Civil Code. So now I will be talking about which different types of matters come under the Uniform Civil Code. So now we will talk about marriage, divorce, and other matrimonial clauses. There is also succession, guardianship, maintenance, adoption, gifts and wills, religious institutions, joint family systems, and matters of charitable trusts. Some of the popular codified personal laws governing matters like marriage, divorce, inheritance, and maintenance are listed below. We will now talk about some of the popular laws that are governing matters like marriage, divorce, etc., which we spoke about earlier. The Indian Christian Marriage Act of 1872. To govern the Sikh marriages, there is the Anand Marriage Act 1909, and for the Muslims, there is the Muslim Personal Law Application Act, which is also called the Shariat, that applies to all Indian Muslims. Now, to govern Hindu marriages, there is the Hindu Marriage Act 1955, which is applicable to the Hindus, Buddhists, and Jains, and also to any other person other than a Muslim, Christian, Parsi, or a Jew, and who is not governed by any other law. Then comes something for the Zoroastrians, also known as the Parsis, the Parsi Marriage and Divorce Act 1937. We will now talk about the important landmark judgments that came. Several landmark judgments have had a significant impact on the debate surrounding the Uniform Civil Code. These cases have addressed issues related to gender equality, religious practices, the need for uniformity, and here are some notable cases. First comes the most popular case, that is the Shah Bano case, and this is one of the most famous cases because Shah Bano was a Muslim woman who sought maintenance from her husband after being divorced through the Islamic practice of triple talaq. The Supreme Court later ruled in her favor, recognizing her right to maintenance under the section 125 of the CPC, irrespective of her religion. Now, what this did was it sparked a nationwide debate again, and uh, it led to the passage of Muslim Women Protection Act in 1986, which limited the application of section 125 in cases of Muslim divorce. This highlighted the need for reforms in Muslim personal laws. Now comes the Mary Roy case. In this case, Mary Roy, a Christian woman from Kerala, challenged discriminatory provisions of the Travancore Christian Succession Act, which favored male heirs in the matter of inheritance. The Supreme Court later ruled that gender discrimination in inheritance laws violated the constitutional principles of equality. This case again sets a very important precedent in gender equality. Later, coming to the Danial Latifi case that happened in 2001. This case involved issues related to maintenance of Muslim women after divorce. The Supreme Court emphasized that Muslim women have the right to claim maintenance beyond the iddat period of waiting after the divorce under the section 125 of the CPC. Again, this comes to gender justice, equality, and personal law should not infringe upon these principles. Coming next to two more very important landmark judgments, that are the Sarla Mudgal case and the Lily Thomas case, which happened the first one happened in 1995 and the second happened in 2000. Now these cases dealt with the practice of bigamy among Hindu men. So what a lot of Hindu men would do is they would marry their first wife and later convert to Islam and marry the second wife, marry another woman without divorcing the first. So now the Supreme Court held that such conversations for the sole purpose of bigamy were unacceptable and not protected by the freedom to practice religion. Now what this case did was it raised questions about the need for uniformity again and a reform in personal laws to prevent misuse. Now coming again to the Shaira Bano case that happened in 2017. So now these were a number of petitions that were filed, and this is a landmark judgment again where the court declared the practice of triple talaq as unconstitutional, stating that it violated the rights of Muslim women. Again, this judgment was seen towards the reform of Muslim personal laws. Now coming to Uniform Civil Code and the freedom of religion. The Uniform Civil Code and freedom of religion. In the SR Bommai vs. Union of India case, as per Justice Jeevan Reddy, it was held that religion is the matter of individual faith and cannot be mixed with secular activities. Now, secular activities can be regulated by the state by enacting a law. But in India, there exists a concept of positive secularism as distinguished from the doctrine of secularism that is accepted by two places, that is one, America, the United States of America, and some European states. Now there is a wall of separation between the religion and state in India. Positive secularism separates spiritualism with individual faith. Now let us go to the last topic, that is countries with a UCC or uniform personal laws. Now another example, an example where the UCC is followed is Turkey. Now Turkey is a country that is historically a very Muslim majority country which adopted a UCC in the early 20th century under the Mustafa Kemal leadership. The UCC abolished the Islamic legal provisions and introduced a secular legal system. Now what Turkey's experience shows us that a UCC can be implemented even in predominantly Muslim countries, emphasizing secularism while respecting religious diversity. Now let's come to the next country, that is Tunisia. Tunisia is once again another Muslim majority country which implemented a UCC, making several reforms for Muslim women again in personal laws, including marriage, divorce, inheritance, maintenance. Now let's talk about countries without a UCC or uniform personal laws. First comes the United States of America. The United States does not have a UCC. Instead, it follows a system of state specific family laws leading to variations in marriage, divorce, and inheritance laws across states. Coming to the last country, that is United Kingdom. Now this is very interesting because the UK has a diverse population with various religious communities, but it does not have a UCC. But so how does it work? It allows religious arbitration councils such as Sharia councils for Muslims for family matters, which operate parallel to the legal system. Now what India can do is look at all the other countries that has the UCC and slowly learn from each and every thing, the inclusion, the cultural diversity which has been put into these laws, and form a UCC so that it is a much more safer environment for women in this country. Thank you so much.
Jaanya, thank you very much. The way you have presented the topic showed that you have done a good amount of research, because you spoke about the debates which have taken place in Constituent Assembly. So that really needs a research to be done as on today, because that itself has happened a long time, 75 years back, and you are researching that. So that's a very nice thing on your part. You tried to cover the Indian scenario. You gave the examples of countries which are doing, which are not doing. So thank you very much for this. So small token from Hammurabi to you.